Welcome back, everyone. This is our third panel, last but not least, of course. And I'm going to be introducing the moderator, Professor Ronald Rosenberg. He's a professor. Professor Rosenberg joined William & Mary faculty in 1982. He served on the legal staff of the Environmental Protection Agency in Washington, D.C. He's taught at Cleveland State School of Law and was a visiting professor at the University of North Carolina, Chapel Hill School of Law. He was also Fulbright Senior Scholar. Professor Rosenberg is the author of Controversies in Constitutional Law, Evolution of the Law of Takings, and articles in the Duke Law Journal, Journal of Local Government Law, Annual Survey of American Law, the Arizona Law Review, and the North Carolina Law Review. He's a general editor of the Virginia Local Government Law and the co-author of the Environmental Policy Law and Problems in Environmental Law. He's also a frequent speaker on environmental and property issues. So, please join in welcoming Professor Rosenberg.
Well, to the diligent go the spoils. I want to thank you all for staying here to this 2:58 on Friday afternoon, and I'm sure you'll be rewarded with learning some very interesting and useful things. I just came up here yesterday from down the road, down in Tidewater, Virginia, where I live, and to join this enterprise because I thought it was about a very interesting topic. Happy to be with you, but I looked at the topic, the title of this, and I wondered what was being reclaimed. But anyway, these titles get developed in ways that I guess I can't necessarily understand. One of the things I'll say before I introduce our two speakers is about this kind of federalism emphasis in this session today. You know, federalism, for the law students here, they know this from taking constitutional law, is a theme that is one of these recurring themes that doesn't really go away. It just changes its issue from time to time as policy questions arise and fall. And the question is not only enduring, but it's a highly charged kind of issue about who has authority to do what, when is authority exclusive, when does it overlap, and as kind of general as that may sound and uninteresting, it's very highly charged, and surprisingly strong feelings arise about intrusions into either state or federal autonomy and or knowledge or experience, and so these issues arise commonly, and those of you who've studied this in your courses or otherwise will know that. Thirdly now, I'd say one of the things that struck me recently, and I've only recently gotten interested in, is this whole idea about the significance of energy policy and how energy is produced in our society. Like many people, or maybe I'm overstating this, I had no idea. I just turned on the light switch and the electricity went on, and I had no idea that that was the end of a process of production and transmission until recently when I started to study this somewhat. So that energy is a very, it's kind of a very important topic in terms of economic implications, costs, environmental implications, and I would further say social ones also. Having traveled a lot around the world, I've noticed solar collectors on the roofs of many houses in many cities, and not around where I live at all. And that was the accepted social way of building a house or having a structure, is collecting hot water for either heating or some other use. And so my point, though, is that this is a very significant issue, and it's the energy policy, or the lack thereof here, of a national one at least, is very, very important. As you can see, we have discussion so far, and I thought the last panel was very, very interesting to me, raising issues of how the regulation of this very complex industry, the energy industry, the electricity industry at least, should be laid out and how it should be established. And as you can hear from, for those of you who don't know much about this, there are state and federal roles. And for those of you who haven't studied it, you probably don't know the detail of this allocation. And for those of you who have studied it, perhaps there's a little fogginess of where the lines are drawn in terms of exclusivity. But the important thing I think you should take away our segue into to this panel is that the states still maintain important functions, both regulatory functions, setting rules and regulations for conduct of various businesses and activities, and pricing regulation of how much is this going to cost. And so the state agencies you've heard about and our Virginia Attorney General's representative representing kind of the state level there showed you the kind of important function that these corporation commissions have in states. So the states, I think, should be taken seriously. They have important functions. And this is where we lead into the discussion today. Taking this down from the national level or international level, if you will, to the state level and to resource development. That's really what we're talking about here. We're talking about, I guess, natural gas centrally with regard to a state, a particular state, and the state being the adjoining one, West Virginia. And we have two gentlemen who will talk about the West Virginia experiment with experience, rather, with, and maybe it's an experiment, with state legislation that governs the development of that resource. And bringing this down to a very specific level. And what I would ask all of you to do is, I guess Mr. Lay will speak. Who's going to speak first? Mr. Lay will speak first, and Mr. Reel will follow him. They drove up in the car together, so I guess they can probably get along with kind of an arbitrary switching. And what I'd like you to do is perhaps hold your questions until afterwards, and then maybe we can answer them all in a collective fashion. So, if without further ado, let me pass the podium over to Mr. Lay.
Good afternoon. I want to thank you very much for asking me to come make a presentation. And I really spent a lot of time preparing something that I find would probably take hours to explain. So I'm going to be very general and try to cut my presentation down to a few minutes. And I want to talk basically about one one topic that's been extremely controversial in our state over the last several years with the advent of more resource plays in oil and gas development, specifically the development of shales and also new technologies for the development of petroleum in general. And the primary topic that I was going to focus on is one of pooling of properties for the development across several different ownerships to allow the resource to be developed. And it's a pretty complex issue. And you know, what is pooling? Well, pooling in itself is what occurs when a well is drilled and there are multiple surface tracts or multiple owners within the development of that well, or a proposed well under the statute. And this specific pool or pooling would allow the either voluntarily through agreement among the parties or the owners of a tract or lease of property to agree on some division of both the production and the revenues from a well as it's developed. And in the absence of that, the state has given us, through statute and rule, the ability to, upon request of an interested party, compulsory pool the individuals together to allow the development. Generally, that is pooling. Again, it's one that can be done either voluntarily among the parties or compulsory, or, as heard a lot, forced pool. Currently in West Virginia, we have two provisions for pooling that are in the statute. The first one comes under the Oil and Gas Conservation Commission statute, which is the statute that deals with deep well development in the state of West Virginia. The second provision is in the coal bed methane statute, which allows for the development of coal bed methane. The Conservation Commission statute was enacted in 1972, just from historical background. And I think the legislature, when enacting the statute, intended to both promote and protect all the parties involved in the development of the resource. They had determined that after years of oil and gas drilling, more than 100 at that time, that the shallow reservoirs had already been explored, developed, and that the deep reservoirs needed some additional regulation. So that statute allowed for that, and I think it was intended, again, the paramount focus of the statute was to prevent waste either in the oil and gas resource, the surface disturbance, and to ensure that everyone received a just and equitable share of both the production and the revenue, as I said before. Now, a deep well in West Virginia is a well that's drilled to a depth below the uppermost member of the Onondaga group, which is in the Devonian series. That varies in depth, and I'm not going to try to explain that. And there are basically two provisions that I want to talk about in pooling. There's a provision for individual well pooling or a drilling unit formation. There's also what is known as special field rules, which allows the development of multiple drilling units that are set up based upon evidence presented in a hearing in front of the commission that is dictated in size by the physical characteristics of the rock formations and the reservoirs that we're dealing with. So, that being said, either type has the same mechanism with regard to forced pooling or voluntary pooling. It's initiated by any member or affected or interested party that's within the unit itself. Therefore, anyone who drills the well, who is a lessor of the minerals within the well, or believes he may be affected by the production of the well, can make an application to the Oil and Gas Conservation Commission for a hearing to determine whether a pool will be a unit will be established within a pool. And I've talked about pools a little bit and pooling, but I think I probably ought to define the term pooling. And it is an underground accumulation of petroleum, which is in itself a single and separate natural reservoir that has a constant pressure regime throughout the entire section. So anything that is drilled into that area, where it be 1 acre or 5,000 acres, the pressure throughout the entire area is affected by that one instance. So that's a pool. At this point, once you have made application, there are specific criteria that must be met, and they are dependent upon the surface topography of the area, the property lines of the land, the physical plan for the development of a well or wells to be drilled, the depth at which they're to be drilled, the type of hydrocarbon, and so forth. The Commission has some leeway as to the size, shape, and terms under which a unit is formed and which a party is pooled. And all parties have the right and the ability to present evidence to back up their position. The evidence that is taken is expected to be both technical and presentation, as well as knowledge with regard to ownership of the property, and I guess those type of criteria. Again, the primary focus is to protect the relative rights of all the parties, whether they be a royalty owner, a offset operator, or in the case of coal bed methane, the co-owner and co-operator as well. Once the Commission has held a hearing and received all the evidence with regard to the geological data and evaluated that, they will make a determination as to whether to proceed with forming a unit and pooling the interests or denying the application. And this is an instance assuming that the Commission would grant an application, which I think affects the public more than anything else. In so doing, there are a couple of criteria that allows for the protection of the correlative rights, and it also puts some burden on the developer. Anytime there is a unit formed, it not only protects the mineral owner, but it also addresses issues with the surface development, in that it would require at that point a easement and right-of-way and consent agreement from the surface owner to allow development to occur. So before that well could be drilled under a pooling, they must not only have the mineral estate, but they must get the surface owner's permission as well, which is part of the statute. Secondly, it gives the mineral owner state an option for participation in the well. And there are actually three options under the current statute. The operator or owner can choose to be treated as a lessee and accept terms that are acceptable for pricing, rentals, royalties, and those would be set by the evidence presented at the Commission hearing and approved by the Commission. The second option would be to participate as a working interest owner and pay your share of the cost and the risk of drilling and developing the well. And lastly, the third would be to participate as a carried working interest owner, in which case the contributing parties would drill complete and produce the well, and would receive your share of revenue until, in the case of the deep well, they were repaid 200% of their capital investment, or in a coal bed methane well, 300% of their capital investment, but basically under the same terms. I think there are a number of benefits to pooling. of oil and gas interests. And the first one, of course, is, the first one in my mind is the prevention of waste. It prevents not only unneeded and multiple wells being drilled into a reservoir, it provides for the uniform development of the reservoir in some orderly manner. It also it should prevent the loss of leaving the resource in the ground and not being able to produce it. It allows the parties to voluntarily agree to the terms for development. And it also allows, in the case of compulsory pooling, them to have input into what those terms are under the direction of the Commission. Again, one of the other terms, and you may say it's a benefit or not a benefit, but it also gives the surface owner some say in a mineral matter, which is a pretty controversial topic as well. As far as the current code, the one point that it does not adequately address, and we have tried for several years to address, and part of the new statute does address it, and I think Mr. Reel will speak to that as well, or in better terms than I can. But actually, the deep well statute and the coal bed methane statute do not address horizontal drilling, which is one of the technologies that have improved dramatically over the last few years, the ability for us to recover oil and gas reserves from both conventional and non-conventional reservoirs. 5 years ago, there were about 5% of the wells drilled in this country were horizontal wells. And today that number is closer to 60% of the wells drilled are horizontal wells. They're utilized in the resource plays in what are considered unconventional reservoirs, primarily shales and carbonates. I think another consideration is that continuing further with pooling or unitization, the decision on whether or not to force pool a tract should be based upon scientific evidence, and it should allow the governing body, whether it be the Conservation Commission or other boards or commissions, or even the state body, broad enough authority to look at exceptions, because we're dealing with formations that have different characteristics, and you need to have that flexibility. And I think the statute that we have currently does not address for deep wells either multilateral, which are very significant, particularly in coal bed methane, nor does it address in deep wells multiple horizontal wells drilled from the same pad, which is another technology that's being used. Finally, I do think that the protection of relative rights of all the parties, at least by having an opportunity for them to have a forum to present their opinion and ask for consideration, exists through the boards and commissions that West Virginia offers. That's it. Thank you.
Thanks. My name is Phil Reel, and I'm really pleased to be here. The professor indicated he was wondering how he was going to get students to attend class on Fridays down in Luminary. Obviously, some of you have managed to hang in here today. I'm not sure why, but you have, because it must be getting credit for something. I don't know. But I got to tell you, I made a rather long outline to cover the recently enacted Horizontal Well Act in West Virginia, which is extremely complicated, not nearly as complicated as what Mr. Lay has to deal with over the Oil and Gas Conservation Commission. But for those of you that are thinking about a career in mineral law, please understand that that's one of the things that you've got to deal with if you're going to represent people either in coal or oil and gas development here in the Appalachian Basin. The matters of pooling and unitization are extremely important. They're highly technical, but they're also very essential to the efficient and conservative methods of drilling and producing oil and gas for everyone. Now let me say that when I prepared this outline, I didn't know what the hell I was doing. You know, I covered this whole big long outline, and it wasn't until this morning that we're riding down and I have a chauffeur, Mr. Lay, that I really read and see what the heck I'm supposed to be doing. So when I get here, I had a really entertaining presentation, which is out the window at this point, and I started making notes back there today, as you can see. And it reminded me of a situation back in 1989. Governor Caperton in West Virginia at that time had just gotten elected in November of 1988. I was fortunate enough to head up the transition team and then serve as his chief of staff. And somewhere in February or March, we traveled over to Washington to brief our congressional delegation on just how great things were going. And we're coming back to the Greenbrier for the National Coal Association's conference and for him to deliver a speech. Well, we leave D.C. about 9. Well, we're getting ready to leave D.C. about 9 o'clock and fly to Lewisburg, West Virginia. When we get the phone call that there's been a wildcat strike in the coal fields. Well, if you're running a state government whose revenue stream is highly dependent on severance taxes from coal, then you become concerned. And when we get to the Greenbrier and we find out how serious this really is, we decide it's time to rewrite the speech for the next day. So we both start reworking this speech, and I take half and he takes half. And it looks a little bit like this. There's arrows here and arrows there and so on and so forth. And you know, we're up to about 3 or 4 in the morning, and we get this done. And here goes Governor Caperton down to the breakfast. He's the keynote speaker. We're walking down there. He's going over. He gets up there to the podium. He looks at it, and being the good, Samaritan that I am, I'm standing in the back of the room, out of the way. I know my position in all this. All I'm going to do is nod my head yes or no. He starts with this speech, and he has to confess he's dyslexic. He says, Phil, I don't know where in the hell these arrows are supposed to go. And so he just speaks off the cuff. So that's what I'm going to do mostly today. That's a long time to get there, but that's what I do want to say. And then when I realized the topic was federalism, I thought, well, good God, I could have talked a little bit about the Interstate Oil and Gas Conservation Commission. There was a time when I got to be a member of that body and vice chair. That you had to be a governor to chair it, and I couldn't become governor, so I went ahead and just took the vice chair's position for a couple of years. But that organization, when we talk about federalism, that organization looks at state regulatory programs over the activities of drilling and producing oil and natural gas throughout the many states in our country. Makes recommendations, tries to establish some minimum criteria that one should consider, and then often audits and evaluates those regulatory programs and makes suggestions to the states for improvements. Now, but it is a state-by-state proposition in terms of regulation of the activity of oil and gas. I think any discussion of oil and gas, I think we have to talk about the relationship of that topic to just conventional real property law. And if we think about the top of this podium, let's say the top of this podium is 1,000 acres that somebody got through a huge land grant, maybe back to the King of England. And what makes things difficult is just west of the mountains here, when people realize that coal and oil and natural gas, both in Pennsylvania and West Virginia primarily, were valuable commodities. And Mr. Lay had this 1,000 acres. And as he learned it was a little bit valuable, and all of a sudden his daughter comes along and says, we'd like to have a little homestead here. And so, he sells them 20 acres, and we're moving from that agrarian economy, and people were getting out of their big farms, and they began to sell small pieces of this. And they would sell only the surface of that property. and reserve unto themselves the minerals and the right to extract those minerals together with rights of ingress and egress to and from in order to accomplish the extraction. Otherwise, the minerals were worth nothing to them. And so you end up in this situation where you have severed estates in real property, particularly in West Virginia and west of the mountains. East of the mountains, not so much. But not only do you have somebody maybe owning the surface, another party owning the coal, another party owning, various parties owning various strata of coal. Some people owning natural gas down to a certain depth, other people owning natural gas down below that depth. And then as families decided that those minerals were worth something, they didn't give them up. And so through generation, through generation, and through generation, ownership became very, very fractionated. And if anyone that has the opportunity, I don't care what area of law you go into, do a title exam one time just to learn all you've heard in property law and contracts. That will give you the background. So it is in that, all those different ownership levels obviously builds a lot of conflict when you're talking about regulation of an extraction activity. And I'll try to stick to natural gas because I just don't know much about coal. So you've got surface owners who have little or no economic benefit when that natural gas and that oil is extracted. So naturally they've got, wait a minute, I'm getting nothing. I'm seeing my property disrupted for really a short period of time. And conventional drilling, before the advent of horizontal drilling and the exploitation of the Marcellus Shale in the way it is done now, with utilizing huge volumes of water pushed into the ground under high pressure in order to fracture a very tight formation, the Marcellus Shale, and perforate it effectively, fractionize it. What you would have is a situation where, in conventional drilling, you move on a well site, maybe displaces about an acre or less, 200 by 200 pad. You drill, you move on Sunday, you move off on Sunday. You've drilled 5,500 feet, 6,000 feet perhaps. Move off, you let the very lazy of the world figure out where the production's going to come from, how you ought to perforate the well, how you ought to treat it, foam frac or water frac, sand frac, whatever it might be, in order to generate the production, force it up the hole. And all that's done and you've reclaimed and you're out of there in 60 days. So that wasn't too much of a problem for somebody just owning the surface. But what happened 3 or 4 years ago, when somebody decided that the Marcellus Shale, which we drilled through many times in conventional drilling, just didn't see it as a potential producer, but by utilizing horizontal drilling, setting the charges, fracking with huge, huge volumes of water, this whole thing changed. Because you'd have a 5-acre well pad, you'd have hundreds of trucks of water moving on and off, day in, day out, filling impoundments, millions of gallons of water being utilized for this purpose. And there was significant displacement and disruption of the use and enjoyment of that surface property using a 5-acre pad, a lot of activity going on, creating effectively an industrial site in areas of Pennsylvania and West Virginia that didn't previously have industrial sites. And you're drilling approximately 6, sometimes even 8 wells on that pad, going down, under, and out in different directions to very efficiently produce the Marcellus Shale and generate a very prolific wells. And so the public obviously says, wait a minute, we can't tolerate this sort of situation. In West Virginia, to its credit, the Department of Environmental Protection utilized its inherent powers to modify most of its major policies and effectively established greater engineering standards for the construction of impoundments, for the building of well locations. They set up the criteria for the withdrawal of water from state streams and rivers, and developed a water utilization or a water use tool on their website. Disposal of frack water, disposal of drill cuttings, on and on and on. But the problem with it was there was a perception within the public that nothing had changed. And a lot of that had to do with trucking. The Department of Environmental Protection couldn't do anything about movement of hundreds of heavy trucks across roads that were not intended to be used in that manner. But lo and behold, here comes the Department of Highways with their own policy that set up a bonding and a pre-drilling assessment and holding people accountable for literally improving roads both before, during, and after the drilling process had been conducted in a given area, and spending large amounts of money to get that done. Now, so where does that bring us to? Still, the public wasn't satisfied, and largely it was because the Department of Environmental Protection was saying, we don't have enough inspectors to make sure everything that's being done in the field is being done correctly. And that, the linchpin for that was that under the conventional drilling statute, they had no different drilling statute at this point in time, permitting fees were set within statute, and they were only $400. And for a conventional well, it was fine, because there wasn't that much to review. But with this, there was. And so that alone was going to take a statutory enactment. Governor Tomlin, in order to also help sort of enhance all this, had an executive order that effectively embraced everything that the Department of Environmental Protection had done, and a little more. Still, we weren't able to protect the rights of surface owners in the manner in which they ought to be protected, perhaps, and that needed to be embraced in statute too. There wasn't that flexibility of policy to deal with that. And so, in December, after a lot of behind-the-scenes work, the governor's office drafted what we now know as the Horizontal Well Act, and did a very effective job at building consensus, primarily within industry and primarily with the legislature. Industry made a number of concessions, recognizing that they wanted clarity and certainty in order to move forward with this activity. Surface owners were not satisfied, environmentalists were not satisfied, but within 3 days a bill passed. And it wasn't, not that it was without efforts at amendment, just that the work had been done behind the scenes to make this happen. And why was that? And it's the first state, really, to effectively enact such an act, at least in the Appalachian Basin. Pennsylvania just had one, I believe, that passed and may be waiting the governor's signature if it hasn't already been signed. Ohio, I expect, will be dealing with this issue as the Utica Shale begins to be developed in that state. But why was this so important to get this done? Jobs. I mean, there's an economic factor here that cannot be denied. It's jobs, it's billions of dollars in investment. These are very expensive wells to drill. When you talk about drilling 6 wells on a pad, that's a $30 million investment. When you drill 400 or 500 of them in state in a period of time, that's you can add it up and figure out what it is. But more importantly, it also plays a role. We've heard a lot today talk about alternative fuels and renewables, all of which are important for us to be, as a country, for us to be considering. And frankly, had we been considering something else other than not having an energy policy 30 or 40 years ago, perhaps we wouldn't be having this conversation. But fact of the matter is that if we would simply have converted the commercial vehicular fleet in this country and did away with the dependence on diesel fuel, our air would have been cleaner, and we could have utilized natural gas as that long-term transition fuel, and commodities would have moved from manufacturer to storefront less expensively and cleaner, and we would have saved lots of money, hopefully in defense of not having to defend the shipping lanes in the Middle East, as we are now doing. And think of a lot of that money that could have been saved that could be used for education, for clean tech research and innovation. But that hasn't occurred. It still can occur, and we've got a long period of time before we can effectively have enough renewables and alternate fuels to meet the energy needs of this country. And so natural gas is a clean burning, very efficient to extract and put into place into market fuel that could satisfy that. But I want to get back to the bill. So that long outline that anybody may have, I've got to reduce basically to a page now. And I'll tell you some of the highlights of that bill, and then I will probably try to shut up. It's hard sometimes, it really is. But the fees for permitting a well were increased by 900%. $10,000 for the first well on pad, and $5,000 for each additional well. And what that does, it allows the Department of Environmental Protection to staff up and have a very competent team of people evaluating well permits, putting more inspectors in the field, and making sure that as we develop this resource, we do it in a way that is sensitive to and protective of the environment. It requires operators to enter into agreements with the Department of Transportation / Highways to repair roads, to do pre-drilling assessments. They've got a bond out at $250,000 in a given county, or $1 million for a statewide bond. There are no less than 7, I believe, notices that surface owners get as to what is going to happen and to their property, and opportunities to come together in an agreement with the operator, the oil and gas operator, in terms of damages to their property. It also gives them far more rights to comment on the drilling applications and for the DEP to take into consideration what those comments are and how they might avoid conflicts. There's a greater transparency with what's going on here. There are very many significant mandates to the DEP's website for information to be posted and available to the public. There's an opportunity for a member of the public to go onto a registry and select counties of interest to them and to receive any and all permit applications that are submitted for wells in those counties. Additives to frack water are to be disclosed to the DEP, and it's done so. That was already actually being done, but it's now in law and not just policy. Increased setbacks from dwellings, water wells, streams, and other waterways. I know the New Pennsylvania law, I think, has a 500-foot setback from dwellings. In West Virginia, it's 625 feet. We have a 1,500-foot setback from any domestic water well used for purposes of the home, as well as streams and other waterways. There is a under drilling for conventional wells, there's a presumption that if a water well is contaminated and is located within 1,000 feet of the drilling activity, there's a presumption created that the drilling activity caused the contamination to that water well. I have to tell you that in all my years of dealing with oil and gas law, which is about 35 now, I don't think there's been one case that has been moved under that statute. However, it's now increased for purposes of horizontal drilling to 1,500 feet. If you drilled if the producer, the operator has drilled a well to generate water to go into an impoundment to be utilized in the fracturing process, then they have to flow test all wells within 1,500 feet and also check them for quality in a pre-drilling assessment before they drill that. Just significant, very significant additions to the permit requirements. A lot of them have to do with increased engineering standards for site construction, for impoundments, for pits to contain drilling waste. There's new policies in place for safety, for water management, validating your water withdrawal locations, for pit reclamation, for disposal of drill cuttings, all those sorts of things. And then there's extremely broad authority in this act to the DEP to condition permits on various, whatever conditions they believe ought to be there for the safeguarding of the environment and human safety. Strict standards for casing of wells. Of particular note, probably for people with interest in Virginia who might matriculate over to the eastern part of West Virginia where there's some karst formations, they've got to develop a specific policy for drilling karst formations. There are both civil and criminal penalties for bad actors. Studies are now on the books for mandated for air, pits and impoundments, noise. But what it does give those who are in this industry investing a lot of money the opportunity to have some clarity and some certainty as to how they must perform their operations to the law, and allows them to make a reliable decision they can rely on in terms of their investments. Thank you.
Okay, we've run a little late now, but if anybody has questions about the two presentations, which deal with a number of kind of in the news topics about liabilities from fracking and regulatory regimes that have been developed. In the back, yeah.
Yeah, a couple of quick questions. One on, there's been a big focus on the part of the industry because of continued anemic domestic demand for natural gas to export gas produced in the Marcellus Shale outside of the United States. Does that change if an increasing amount of regional natural gas production is indeed deemed for export out of the United States? Does that change your level of enthusiasm for this? Second, we mentioned that each well costs about $30 million or so of investment. No?
You put about 6 wells on a pad, so that's where your 5 per well would be about $30 million.
All right, so a $30 million investment, which is significant. How is that number, I'm wondering how that number is related to economic development investment? I mean, is that just the cost of the well infrastructure? Is that well infrastructure manufactured in this region, or is it manufactured elsewhere? And so I'm just wondering if a $30 million per well figure is economic development worth $30 million for the area or not?
Well, let me tell you why it is.
Mm-hmm.
There's various levels. Obviously, shop owners, hardware stores, supply stores, pipe manufacturers, all are benefiting from that. Local employment in our state actually is below the national average, which is a pretty significant thing for West Virginia. But more importantly, the Marcellus Shale and the Utica Shale in the upper Ohio Valley and the Utica Shale that moves farther west have a very high BTU content, which means that they have components of ethane and propane and other butane that can be extracted and utilized for a lot of different purposes. But what the predominance of this, well, I'll call it wet gas, means is that as gas processing plants are capable of stripping those elements out, and as FERC says, 14, that you can't move that gas in interstate pipelines at that high of an MMBtu, and it's got to be stripped out. So that means there's going to be a lot of ethane, which means that you're looking at perhaps having the opportunity to site ethane crackers in the upper Ohio Valley, West Virginia, Ohio, and Pennsylvania. Now, what does that mean to us? Each of those are going to be probably about a $4 billion investment. It takes 7,000 to 8,000 construction workers 4 years to build one. But more importantly, what does it do? Within a 75-mile radius of that, it probably attracts manufacturing opportunities and more jobs. And those manufacturing opportunities would be primarily in the plastics, making anything from automobile parts to plastic bags or cups or whatever it might be. But so the spin-off of that cracker is estimated at about 12,000 jobs each. So it's a fairly significant economic driver for the northern half of West Virginia, western Pennsylvania, and eastern Ohio. You know, the places that sell trucks and vehicles, I mean, they're salivating. They've had great years here the last 2 or 3 years. The hotel and restaurant owners have had a heyday because somebody who works in that industry who might live in central West Virginia but has moved with that rig up into northern West Virginia or Pennsylvania, they obviously stay in a hotel. And it's just, it's been in that sense, it's been pretty significant.
Other questions? Questions? I have just one question about liability. Under in the press, there's at least some complaint or dispute about the water contamination effects. In West Virginia, has there been any litigation by people who claim their water has been fouled by this activity? And if so, what has been the result of that? And then I guess the third question is, how would this legislation affect future litigation over adverse consequences like that?
I'll do my best to answer that. To my knowledge, there has not been any litigation. However, not over water sources that are used for human consumption, we'll put it that way at this point. Now, if there's a contamination of a fresh water source in violation of the Clean Water Act, then somebody's got problems. But we've not had it. Now, are there episodic events that occur? Has there been something happen where there's been a spill or this or that or other that's relatively benign and remediated within hours? Yes. Have people been fined? I'm sure they have been. But in terms of litigation, I don't know of any. I don't know that this statute would impact that. And I probably should mention that those who are interested in the real estate part of this, a surface owner has basically, under common law, the right to recover damages from an operator to the extent that the operator engaged in practices that were beyond what was reasonable and necessary for the extraction activity. It was that way in West Virginia until 1982, when we had the Oil and Gas Compensation Act passed, which increased the opportunities for surface owners. That not only could they collect under the statutory remedies that were provided there, but they could also collect under the common law as well.
Thank you.
I'm going to take just one moment, no more than 3, I promise, at the very end of the day to wrap us up. And I want to do that by telling you a tiny story. Those of you who know me know that I'm happiest found in the archives, usually the presidential archives, Kennedy and Johnson in specific. And when Johnson took office,
he inherited a bit of a governmental problem. And that was that in recent decades, there was an enormous proliferation of small governmental units, cities and counties that were organizing themselves into functioning governments. In addition, there was a huge expansion of the federal bureaucracy. Most of that was done without any real attention to either structure or how on earth all these units were going to actually communicate with each other and cooperate. And Johnson became very concerned about that. One of the first things that he did when he came into office was to commission a study on intergovernmental cooperation to figure out what was going on out there and what needed to be done to clean it up. One of the first problems that he noticed was that the federal agencies, which were divided into governing regions, actually weren't aligned. So in other words, one agency might have Tennessee as a part of a certain district, and another agency would have Tennessee as a part of a different district. So he issued an executive order that in fact only contained a couple of sentences of text. The most important part of it was this nicely drawn, very sort of fifth grade looking US map with black lines stating that all of the federal agencies would now map their regions to this one map. And at the same time, he asked his administration to start thinking about what intergovernmental cooperation meant and what on earth it was that federalism meant. And especially in an era of television, he asked for visual metaphors. And today we saw a spider's web and these various overlapping circles and all these different ideas about what federalism looks like. The Johnson administration cooked up the idea of a marbled cake, chocolate and vanilla. And it was going to be folded in and on top of itself, but all inherently one thing at the end. That was the idea of the metaphor. It was inherently one government, and it was only going to effectively function if it was one government. Now, as it got to the very end of Johnson's administration, he wrote this speech with the help of one of his aides. I was taking down notes for him. Now, that speech was actually never given, which is both good and bad. It's good in that he never sat down and cleaned it up and made it pretty and toned things down for the public. It remained exactly what he was thinking. In his words, sometimes a little bit on the strong side. The irony of the speech never being given is that, in fact, it was never given because of the very reason that he was worried about in the speech. That speech, which he had intended to become his capstone speech of his administration, was begging the American public to think and talk about federalism. That was what he wanted to do. In the end, apparently, his advisors concluded that given other events that were happening at the end of his presidency, it was unacceptable for him to give this big speech, which was just on, as Professor Stein mentioned this morning, the incredibly unsexy topic of structure of government. They thought that just wasn't going to work. But what Johnson was so incredibly worried about in this speech was that there would never be a calm moment. Never be a time when we didn't have all of these pressures on us. Never a moment when we would say, okay, now that we can breathe, let's sit down and talk about federalism and about what the structure and relationship between the federal governments and the state governments is. And so he said, it's always going to be about the crisis or the question of the moment. And if we don't in our daily lives, and he was worried that more than the US Supreme Court do this, he wanted all of us to do this, to sit down and talk about federalism. So I wanted to end today by telling you that little story and by thanking you for making President Johnson's idea a reality, for spending your Friday afternoon talking about federalism. So thank you for being here. Please offer your thanks to our last panel. Logistically, we need for you to fill out some CLE forms for us to get our accreditation. We need evaluations. So they are located on the table outside, and Sam also has for you.
I have the outlines for if anyone is interested in some of the details regarding the new West Virginia statute. They're available up here. We'd like to encourage all the panelists to come down and grab a complimentary mug before you leave, because we're doing it to us and we want to share them with you. And we would like to thank everyone for coming out, and we hope that this will be an ongoing conversation. And many journal members will emerge in the legal community in future years, and hopefully you'll get to know them, and you'll come back to WNL for future JECE events. Thank you all so much for coming.